All right. Welcome to 180 Contracts, Quarter to Lunch and Learn. Today, we are sitting back and we are having a conversation on asset protection and wealth preservation. Let me introduce myself. I am Chayla Jackson. I am the CEO and founder of 180 Contracts. I'm also a trademark and business attorney. A little bit about 180 Contracts before we get started is that 180 Contracts is a contract template company that provides attorney drafted contracts for small businesses, freelancers, and entrepreneurs that are the next best thing to hiring an attorney without breaking the bank. Okay. We are not a law firm. We're not a legal service. I do have my own law firm, but that's not what we do here at 180. We provide attorney drafted contract templates because the reality is that many business owners need access to contracts, but they may not have the funds to hire an attorney to draft every contract in their business. And so therefore we provide a medium that you get the protection that you need while also protecting your coins, your budget. Okay. So that's a little bit about 180 Contracts. One of the things that we launched this year is our education component, and the Lunch and Learns are part of our education component for our community to help you learn more about contracts, the power of contracts, as well as 180 and what 180 Contracts can do for you. So without further ado, let's delve into today on asset protection and wealth preservation. Now, let me say this. This is a lunch and learn. So this is not a webinar. This is a conversation. All right. So feel free to, pull up your notepad, get your lunch, munch, chew, and get ready to learn. But this is really not a formal or any kind of strict structure. Okay. If you're watching this and you have not registered for the Lunch and Learns, you can register at 180contracts.com. And what registration does is it gives you access to the Q&A replay. So this Lunch and Learn will be posted on our YouTube channel at the 180 Contracts on YouTube, but the Q&A is only for those that register. All right, so asset protection and wealth preservation. First and foremost, let's define what that is so that we're on the same page with what we're talking about when we talk about assets and when we talk about wealth preservation. So asset protection is the legal strategies and tools utilized to safeguard assets and protect people, property, people and property against risk, threats, damages, and losses. Okay. So if you see me looking around, I'm looking at my notes. Now that's asset protection. So I want you to think about assets as what are those things, not just in your business, but personally that generate income or has the potential to generate income. These include things like your copyrights, your trademarks, your trade secrets, your frameworks, your proprietary systems. All of these are assets of the business. And your assets can also include your client and customer list. So assets are not just the traditional assets that we think of. They're the other assets. What are the things that are the money making, generating, your secret sauce to your business that helps you grow, that helps you expand, that helps you generate money, whether it's directly or indirectly. Now, that's your business assets. Your personal assets are your assets such as the money in your bank account, your house, your 401k or IRA. What are your personal assets? Because oftentimes when we think about business, it's easy to ignore the fact that you're still a person. Hello, your personal assets can still be on the line if you are not aware of or understand what the terms of the contract are. And that also includes in how you structure your business. So structuring your business, having an LLC and managing correctly is also a part of asset protection. Why? Because your LLC acts as a shield. It protects your personal assets, and it can also protect your business assets depending on how you structure it. So that is the definition of asset protection. But what about wealth preservation? Because there's a reason we're talking about asset protection and wealth preservation. Okay. We don't want to just protect our assets. We also want to preserve our wealth. So wealth preservation is not just the legal strategies, but it also includes the business strategies and tools to protect money, property, and other valuable assets so that they don't lose value or are taken away over time. So one of the things that may like is really easy when we talk about wealth preservation to think about is lawsuits. Lawsuits take money and it can really rob you of your wealth. Another area of in the realm of lawsuits is also if you're sued for copyright infringement or trademark infringement. All of that is a part of the risk to your wealth. So when we want to preserve our wealth and we want to protect our assets in contracts, we're talking about how do we actually do that? What does it entail? And what are some things that we need to consider? All right. So as we go through and we talk about asset protection and wealth preservation, we're not just talking about your business, we're talking about your personal as well. So let's get into contracts and let's just go through this. So what contracts allow you to do when it comes to asset protection and wealth preservation is that one, it allows for you to identify those assets that were created prior to the contract being formed. So many of you have been operating your business. So before you go into a contract, whether it's with a client or a customer, you already have intellectual property assets and other assets that need protection. So a contract allows for you to identify those, but also to put protections in place for those assets that already existed. It also allows for you to identify and put protections in place for assets that will be created during the business relationship. And so what that means is that depending on the type of contract relationship, you are creating assets. That asset can be in the form of things you create for your clients. It can be a signature system you create, a formula that you created, especially if you're doing hair and during treatment of a particular client, you come up with a new recipe, right? That is a asset that was created. And so a contract allows for you to not just identify new assets, but also put protections in place. Who's going to own it? Because a part of protection means you have to be able to own it if you want to protect it. Another thing that contracts allow you to do when we talk about asset protection and wealth preservation is allocate the risk. Allocate the risk. What do I mean by that? There is always risk in business, right? There's risk of someone dying. Let's just be honest. There's risk of someone dying. There's risk of someone suing you. There's risk of something going wrong. There's risk of you making an error. There's a risk of you not fulfilling your obligations. There's a risk of a breach of like you want to think about all the things that could go wrong. A contract allows for you to allocate the risk. What do I mean by that? Well, let's say that if you're not thinking about this, because I had a client that they were trying to DIY their own contract and they had not even thought about this. When you're trying to, say for instance that your responsibilities under the contract are dependent upon the other person delivering materials to you. If you didn't allocate for that risk that they may not meet the deadlines, they may not schedule the appointments, they may not pay you, and you haven't allocated the risk, you can end up putting yourself at breach of contract, meaning they have a legal right to sue you, although they didn't do what they were supposed to do because you didn't properly allocate the risk. The other risk that you may not consider is what happens if the company that you're working with, they go bankrupt. What happens if they file for bankruptcy? That is a risk to you. Why? Because that risks you getting paid for what you're doing. And so a contract allows for you to allocate risk. Same thing if you're in a business partnership and there's risk, you can literally allocate that you're responsible if this goes wrong versus this. Let's do another risk. Another risk that sometimes we don't think about is when clients give you information. So clients give you a photo of them, clients give you something that is a part of their business to use. But what if they don't actually own the rights? You don't want to get sued for something the client gave to you. And so you can allocate the risk within a contract. Another thing that a contract allows for you to do is it allows for you to shift liability and minimize liability. And so we talked about in the last Lunch and Learn about how to limit liability with the limitation of liability clause. But the other areas that you might not thought about is how to minimize liability. So minimizing liability and shifting liability is really important when you want to make sure you're not going to be all on the hook for something. And the other thing that a contract allows for you to do is to address money. We're talking about wealth. Address the money. And so what money are we addressing? You're addressing royalty payments, any penalty payments. What happens if they don't pay you? What's the penalty? You're addressing legal fees. Who has to cover legal fees? You're covering litigation. Who covers the cost of litigation, especially if you win? And other things that you want to address as well. You always want to address the money because we're talking about asset protection and wealth preservation. So let's get into some clauses and things that you want to consider when we talk about asset protection and wealth preservation. But we're going to start with asset protection first. And so let's start with brand, because that's when we think about assets, the first thing that really comes to our mind is like, oh, how do we protect our brand? How do we protect trademarks? How do we protect our copyrights? And so first and foremost, one of the things that I had to explain multiple times in the last 2 weeks with potential clients is that brand protection, your brand, your assets, which is a part of brand protection and helps what you need to protect for asset protection, is more than just copyrights and trademarks. Brand protection also includes contracts because one, when it comes to creative works and copyrights, you can't even own it if someone else creates it if you don't have a contract. So the way you protect your asset, your brand, is you need to write it into your contract. Who owns the trademarks? Who owns the copyrights? Who owns something that has not been, sometimes is not considered, is the proprietary information, trade secrets, and confidential information. Who owns it and what can do what with it. And so when you are thinking about your assets, don't just think about, the trademarks and copyrights, because everything is not protected under there. You need to think about frameworks and your systems, your processes. All of those are not protected under traditional intellectual property law unless it's a trade secret. And so how do you protect it? You protect it in the contract under a non-disclosure and a confidentiality clause section. Because without that, you don't have any ability to recover. And so I'll give a general example. If you are talking about your idea or talking about your process with someone, and then they go and they use your framework, they use your process, they use your idea, if you did not have a contract in place, you have no way to recover. Why? Because processes, frameworks, and ideas are not protected under intellectual property law. So the only way to protect that asset of your business is in contracts. But if you didn't have a contract in place, that means that now somebody is making money off of what was supposed to be coming into your business. So you want to make sure that if it doesn't fall squarely under trademark and copyright law protection, and it's not a patent, it's not a trade secrets require there to be confidentiality. So if you're sharing it, it's not a trade secret. If it doesn't fall squarely under that protection, then you need to make sure you're protecting everything else under your contract, under a confidentiality and non-disclosure agreement. So that's where asset protection comes in. Another area of asset protection that is often overlooked is image rights. Image rights are the rights that we as individuals have to commercialize and profit off of our own image. So my face, my name, my likeness, my sound, my voice, you can't just take my image and then put it on a billboard to market your products or services. That's not how this works. I have a right to demand compensation. And so I want you to think about all the ways in which you use image rights. You may take photos of clients, customers. You may use their photos or their names or their words for their testimonials and their reviews to market. You want to secure that. That's the asset of the business because it's word of mouth. It proves that you are not a scammer in business. So you want to secure that within your contract. Okay. Other areas where you may not be thinking about asset protection that you want to consider in your contract is when it comes to liability. So first and foremost, you'll hear me say this, and I'm gonna say it again. Your personal name should never be at the top of a business contract unless an exception applies. Why? Because you're not protecting your personal assets if your name's at the top. Another area that you want to be like, watch out for, like, watch out. It should be an alarm bell that goes off if you see this. If you see joint and several liability, or libel, pay attention, because what this clause is doing is that it is about to make you personally liable with the business. So even if you have the business name at the top, if this clause is included, that means that you are still going to possibly be on the hook liability wise in your individual capacity, even when it's for the business. So you see this language, joint and several liable, it's telling basically you about to be on the hook to liable. So you want to pay attention. Another area where you want to pay attention in your contracts is if you see a personal guarantee. So when I was setting up my payment processor for my law firm and I was shifting over, one of the things they had in their contracts was a personal guarantee, which meant that if my law firm had, like, someone disputed a charge and they had to debit the account and there were some liability issues, they wanted me individually to be personally guarantee that loss. Absolutely not. Absolutely not. You want to pay attention to that language, because essentially your personal assets as well as your wealth is no longer being protected. And so you may be wondering, well, what do? You always have negotiating and bargaining power before the contract is signed. So my situation worked out in my favor where I did not have to personally guarantee it. So they waived that requirement for me because, again, I paused, I saw it before I moved forward and just signed it. And so for some of you, if you are like, well, I don't want to say no, this is where you speak up. You have extraordinary power in your voice and your ability to negotiate, your ability to understand contracts, your ability to even negotiate what you need in the contract and what you don't want in the contract. To understand all of that is an asset, not just for you, but for your business, but it's also a tool, a strategy to protect yourself. And so I hope that you're seeing that you are a strategy and a tool when it comes to asset protection and wealth preservation. Because if you're unaware, if you're not employing these strategies, if you're not negotiating, you're leaving yourself wide open and at the mercy of the other party. And let me tell you, whoever drafts the contract typically drafts it in their favor. So just like you have, I gave you the warning on joint and several liability as well as personal guarantee. If you are drafting the contract, meaning that the contract is for you, you're receiving services, you're working with someone, this is where now we flip it on its head. You don't want to be personally and joint. You don't want to be be a personal guarantee. You don't want to be jointly and several liable, but you may want the other party to be. And so when you hear like certain things, you may not want it for you, but you may want the other party, the client, the customer, the business partner, to be joint and severally liable. Why? Because I need to be able to recover from you. I need to be able to protect my assets, preserve my wealth. So if your business is out, then I can recover from you. But you don't want to do that for yourself. Okay. So in protecting your assets, and we're, particularly in contracts, it goes beyond just intellectual property. We're also talking about protecting yourself money-wise, protecting your personal assets. And so you want to pay attention to those things. Another area where you want to be mindful of asset protection, and you may not have thought about this, but any information that is shared with the other party after the contract is over, what can they do with that information? Now, let me go to intellectual property, because this is an area where it's also overlooked. If you develop something with the other party to the contract, if they develop something for you, you want to preserve that asset and be very clear on who owns it. I mentioned that before, but Not just who owns it, but who can use it, who can profit off of it, who owns any derivative works created from the copyrights. And if someone can use it, do they have to use it with credit, meaning that they have to name you, list you, refer you? And if they can use it afterwards, do they have to pay royalties? Can they sell it? So there's more language and more protections that you can write in to protecting your assets, especially with intellectual property. And this is where we get into licensing terms. This is where we get into assignment terms. When you understand proper licensing and the difference between exclusive, non-exclusive, assignable, non-assignable, sub-licensable. This is where you get into the ability to really preserve assets. So say, for example, you have a book and the book is doing well. A movie production company wants to take that book and turn it into a movie. Well, guess what? Who's going to own the rights to that derivative work? What about royalty payments? What if it goes into a spinoff of it as a show? Who has the right to shop that around? Okay, do they have to give you credit? I would want credits. Okay. And then you have to think business wise. Do you want royalty payments, or like what's the payment structure going to be? But there's also licensing. And so if you're not aware of all of the rights within a copyright, you could end up giving away your entire copyright when you could have retained some rights and licensed others. Okay. So when we talk about asset protection, essentially knowing about contracts and licensing when it comes to intellectual property is important to protect your assets. Now let's move on to wealth preservation, because it's one thing to acquire wealth, it's another thing to keep it. Okay, it's one thing to acquire, it's another thing to keep it. And so again, when it comes to your intellectual property wealth, we talked about this. You want to think about registration. Who has the right to register trademarks and copyrights? Who has the right to license it? Can they sub-license it? Who has the right to payment? Who has the right to assign it? And then for some of your intellectual property, who has the right to oversee compliance? So you want to think about those areas of wealth, because say, for instance, that you're creating you're doing affiliate marketing, or you're developing a franchise and you're allowing for others to use your trademark, whether it's registered or not. If they use it outside of what it's registered for, or they use it in a way that violates the laws of trademark, you can lose your own trademark rights. And so you want to be able to manage and oversee. Why? Because your trademark is a part of wealth preservation. How does it do that? Because when you have a trademark, especially a registered trademark, what a trademark allows for you to do is when someone is infringing on your brand, that means they're diverting profits and customers and clients away from you. And so you can shut it down. But if you're not overseeing your trademark rights, if somebody is using it outside of the way it's supposed to be used and you lose those rights, that means you also lose the ability to be able to shut down infringers and stop the diversion of what wealth, of the revenue, the income, the clients, and the customers that should have been coming into your business from being diverted somewhere else. Okay. Other places for wealth preservation is, again, think about litigation. Do you have the money to litigate? Do you have the money to fight a lawsuit? If you don't have the money to fight a lawsuit, then you want to make sure that your contract is preserving your wealth, especially in the realm of litigation. And so one way that you can do this, and we talked about this in the last Lunch and Learn, which you can watch on our YouTube channel at the 180 Contracts, is the limitation on damages clause. You want to put limitation on damages. The other area where you want to put protection, and this is something, as I was drafting a template for 180 Contracts, I realized that there were multiple areas where I needed to put this in for this particular contract. And so every contract, every situation has different risk, okay? And so there is an area of law when we talk about shifting and managing risk and shifting liability. One way you can do that is with a indemnification clause. And so I use more broad language that says that you will release, hold harmless, defend, and indemnify. And typically it's us that we want to be indemnified against certain things. Okay. And so depending on the scenario and the risk, you may want that. Why? Because if they are releasing you, that means that they are waiving any claims against you. They're releasing you from liability. If they are holding you harmless, that means they're holding you not at fault. If they are defending you, that means that if you get sued, depending on how the clause is written, say for instance that uh, okay, I'm going to use the example that I just recently had to use. So I am in the process of drafting a sports coaching agreement. Okay, template for 180 contracts. Now, if sports, when it's a coach, one of the things that you may not think about is that we have real life scenarios that go on. People have restraining orders, people have peace orders, people have beef with other people. And when there's sports involved, that comes to what? A game where there is the general public, but also athletes. And so the risk of something happening in the personal life of that individual that's being contracted with, coming into the game arena where the public space is, and the potential of danger means that, hold on, there's a liability issue here for the company that's hiring this coach. So in the contract, what I did was I did two things. The first thing I did was a duty to disclose. Sometimes there's information that you need from the other party that you need that to help you minimize risk and preserve your wealth and protect your assets. So I put a duty to disclose. One of the things I put a duty to disclose in is the coach has a duty to disclose any, as permitted by law, if there is any restraining order or peace order that they have against them or against another person, especially if it's an athlete, if it's a parent, or if it's an attendee. Why am I saying that? Because already, if you have to get a restraining order and you have to get a peace order, we're already dealing with a violent situation or something that is harassing, meaning that if it's against a game attendee and they come into the game, now we have a potential liability issue and we need to alert security. There are certain things that need to be done business-wise to minimize that risk. But let's say that the coach did not disclose that information, and let's say a gunfight happened. Now the victim of the gunfight is suing the company. But you had no idea that there was a risk involved. Well, one of the things I wrote into the contract is that when there is a failure to disclose, that the coach has to what? Release, hold harmless, defend, and indemnify the company. That means that if the person, the injured party, sues the company, the coach now is responsible to step in place. Indemnification is that the other party has to step in place of the company to defend against that lawsuit. That's the power of understanding how to preserve wealth and protect your assets by shifting liability. And so you want to think about what could all possibly go wrong. I'm talking about everything that can go wrong. And then think about what your clients could do that could possibly impact you, could possibly impact your business, and not just the traditional. I want you to think about, depending on the scenario, because every contract is different. Every arrangement is different. You also have to think about your reputation. The harm to your reputation impacts your wallet, your bank account. Why? Because when your reputation suffers, guess what? People don't want to work with you. People don't want to buy from you, which means now we have a wealth issue. So you want to think about all of the things that could go wrong, even impacting your reputation, your business operations, your ability to do the work, liability, risk, all of the things that can happen, including how could anybody possibly die? Once you have that list, then you want to think about, once you have that list of all the risk and everything that go wrong, now you want to think about, okay, do I need certain information? How can I minimize this risk? How can I shift liability? Because some liability can be shifted. Like I just disclosed, the duty to disclose, I shifted that liability. But then there's others that can only be minimized. And so you want to account for that, and you can do that within the contract using some of these clauses. Now, there's other things that you may not consider as a risk. So let's say, for instance, depending on your field and what you're doing, there is a risk of allergies for certain things. So if you're providing food, but you don't know that someone has a peanut allergy, now there's a risk. If you don't know, right, doctors, medical, they always ask, are you allergic to, they ask, are you allergic to anesthesia? Why? Because there's a risk of complication. So that's what I mean by that's the type of risk that we don't shift. You can shift it if they fail to disclose it after you have requested the disclosure. If you don't request the disclosure, there's no shifting of liability. But you can also minimize it by asking questions. This is a business strategy. This is a business. One of the things that I added into the template is a disclosure form, a required disclosure form. Why? Because even within the contract, now you have a form and you have instructions on how to submit required disclosures. So this is, I'm giving you an example of what this looks like in real life context. And so it may be different for your business because, again, every business situation is different. Another area, of course, is dispute resolution. So for many of us, we work with many different clients, and you may not have considered the fact that sometimes clients can stand as a representative of a class and sue you. So one thing that you can do to preserve your wealth and protect your assets is you can put in a class action waiver. And what this clause does is it says, look, you can't sue me as a representative of a class. Essentially, I want you, look, back in the day, when one of your friends got in trouble, was about to get in a fight, what would they do? They would call him back up. And so you went as a group, and if you didn't, then just think about a movie, right, that you've seen, as a group, and saying, look, you got to fight all of us. That's what a class action does. It says, look, you didn't just harm one person, you harmed multiple people. And so now as a group, we're coming. What that means is they can group their resources together. So you have a group of people pulling their resources together. And now you have to defend as only one person. That's one against many. But when you have a class action waiver, you say, no, you got to fight me one-on-one. And I don't know if I said this here, but I've definitely said this. Broke people don't sue. Broke people can't sue. Unless they find an avenue, broke people don't sue. And that is also why big companies and lawsuits can extend a lawsuit. Why? Because it's a strategy. Because eventually you're going to run out of resources to fight. And once you run out of resources to fight me, now I have a leverage. I have a leg up to settle this case outside of court and settle it for a lesser amount than what I would have had to pay. So a class action waiver is a way to help you preserve your wealth by saying, look, you can't pull your resources together and sue me as a collective. You got to come one-on-one. And then, of course, you add in the other provisions that we talked about in our first Lunch and Learn on contract tips for business success, such as the jurisdiction clause, the governing law clause. Why? Because we're saying, look, you can't sue me anywhere. You got to come sue me here. This cuts down on your traveling costs, how much money you spend away from your business, how much money you spend having to litigate. Because if you live in, let's say you live in Georgia and the client lives in New York, but your contract says in order for you to sue, in order for you to recover, you have to come to Georgia, then guess what? Chances are, if they don't have the money to not just sue you, but they don't have the money to travel, pay for hotel costs, pay for food. And look, when you are away from home, what's also happening? Chances are you're taking time off away from what? Work. That also means if you have a family, you're taking time away from what? Your family. And if you're taking time away from your family, chances are if you have kids, you need a babysitter. So that's more money you have to shell out. Those are the hidden costs that oftentimes the collateral costs that are not considered when it comes time to sue in litigation. And once those fees start adding up, they realize that actually it's not worth it to sue you. This is a way that we preserve our wealth in contracts. Another way that you can preserve your wealth in contracts and protect your assets is with a representations and warranties clause or section. What representations and warranties do is essentially, it's kind of like a promise or guarantee that whoever, typically this, I do this for the other side, that whatever they're saying in this section is either going to be true before we sign the contract or after we sign the contract. And if it's not true, it is essentially, it gives you another legal reason to terminate the contract, but also to sue because it's a guarantee. So some of these could be, if you're working with businesses, that the business is in good standing to do business. Another representation or guarantee is that the business has not filed for bankruptcy, or they will notify you if they, within say 60 or 90 days before they file for bankruptcy. That a representation or warranty is that the business is a legal business in their state of incorporation and has not been dissolved. And if they plan to dissolve it, that they must notify you 60 days prior to dissolution. Why is this important? Because you don't want a company that you're in contract with to go bye-bye or file for bankruptcy, and now you can't recover. Now you can't begin to negotiate for intellectual property assets. Why? Because once they file that dissolution and once they file for bankruptcy, now all of the assets for the business are now going to have to go through the legal parameters where you could have gain access and control to those assets and preserve wealth and wealth generating assets prior to that process. So these are representations and warranties. Other things that you can represent and warranty is that the individual is the authorized agent of the company, or thereof are 18 years of old and of sound mind. So depending on what you need them to guarantee, that they are the sole owner of the intellectual property, that no artificial intelligence has been used. Whatever you need them to guarantee, you can put here. And when they breach it, you have another way to recover from them. And so that's how you can preserve your wealth, but also protect your assets. Another area that I don't think I have ever shared, and I'm going to share it here. But you also want to consider, depending on the type of arrangement, is buy-sell agreements within your contract. So if you are in a partnership with another company and, before they dissolve or they terminate the agreement, you can have buy-sell provisions to buy certain intellectual property or to buy the business. You also want to think about non-disparagement clauses. So non-disparagement, I want you to think, again, the reputation of your company. A non-disparagement clause is a clause that essentially prevents the other party from saying, publicizing, or making any type of remarks that literally could disparage other people from working with you or to present you in a bad light. Now, anything that is true, honest, protected under First Amendment speech is excluded from this. Okay, like we can't, if it's an honest review, we can't stop you from saying what the honest review is. But it's like slander, libel, defamation, this falls under this part. And this is a protection because it's not just so you could sue under those laws, slander, libel, all of that. But if it's not in your contract, that means, again, when we go back to where litigation must take place, if it's not within the contract and the other party does this behavior, then what happens is that now you have to go to where they are to sue them. But if it's in the contract, because you have listened and you have your jurisdictional clauses in there, now you can sue them on home court advantage for the remarks that they made that's literally impacting your wealth because it's impacting your reputation. So all of those are some things to consider, things to include, and just really think through the risk, make a list for every contractual situation, so that you can protect your assets, but also to preserve your wealth. All right. So we're gonna shift to Q&A. But I want to thank you for those of you who, signed up. Those of you who are watching this quarter soon lunch and learn. Feel free to drop comments. What your takeaways are. Was this helpful? Was this needed? Have you even considered this before when it comes to asset protection and wealth preservation? And of course, if you want to be a part of the Q&A, you can register at 180contracts.com. Our contract templates take into account some of these situations. Again, it is a template, so we can't cover everything that's specific to your business, but we do think through things that you haven't thought about, just like I mentioned in my example for sports. What happens when there's a gunfight because someone hasn't disclosed the potential risk and liability of it? All of those things that can help you protect yourself in these situations that you haven't even thought about when it comes to asset protection and wealth preservation. And so if you're interested, you're interested in learning more about 180 contracts, you need a contract template, you can go to 180contracts.com, look around. We have resources available for you, as well as check out our contract template shop and shop around and get the contracts you need. So thank you again for joining us. We're going to shift over to Q&A in just a moment, so just stay in the room. And again, my name is Chayla Jackson. I'm the CEO and founder of 180 Contracts. We are the next best thing to hiring a lawyer without breaking the